Welcome to the Business Owners Council, Legal Issues from Growth to Exit.
Most business owners think a lawsuit starts when someone files a complaint, but the reality is that decisions made before anyone steps into the court generally determine success. In this two-part series, we're talking about how smart business owners evaluate disputes before they become expensive distractions. We're talking with Brick Business Law founder and managing attorney Kevin Brick about why lawsuits are won and lost before the lawsuit and how smart business owners evaluate litigation decisions. Kevin, welcome and thank you so much for joining me today.
Yeah, Lisa, thanks for having me.
What do you mean by lawsuits are won or lost before they're filed?
Yeah, I mean the lawsuit itself, from a technical standpoint, it starts when the complaint is filed in court, right? But actually, all the things that build up ahead of time are the components that address whether or not the lawsuit is going to be successful. So when you think about it from a business litigation context, like what we do, we're talking about when the contract was drafted, what terms are there, emails that were sent back and forth, performance metrics, all those things that relate to the underlying contract and parties and their actions and all the things that happened before the lawsuit got filed. Usually by the time the lawyers get involved, all those strong and weak facts have already materialized. So the goal really before a lawsuit is filed is to understand the strength of it and to make good decisions based on a full analytical context of the case ahead of filing the lawsuit.
So that when you get into court, you're ready and you have a plan and you know where you're going.
That's right.
Makes sense. What are the first things a business owner should really evaluate before threatening or even filing a lawsuit?
Well, we like the concept of this thing that's called like a risk map, right? So you think about, what is the harm that we're trying to address? What are the damages? What documents do we have that prove it? What are the weaknesses or the counter arguments? And then you think about things like, well, if we win, does the other side have money to pay the damages, for instance? Or are there attorney's fees provisions that help us recover our fees against the other side if we're successful? And so we look at things like the cost of litigating versus not litigating. And so a good business attorney, we think, should help a business owner evaluate litigation just like an investor would. So we're looking at things like the cost of investing in litigation, the likely return, the risks, the opportunity costs. And I think that's different than the typical approach of a lot of attorneys who, when you come into their office, they say, is this a good case or not? And that's kind of the piece that they say, all right, let's let that dictate the decision about whether to litigate. And we think that's actually just a piece of the total consideration you should make when you're deciding whether or not to file a lawsuit and pursue litigation.
I think as a business owner myself, we never did things on the principle of it. You had to actually think through that process. And so my question for you is, why is being right not enough in business litigation?
Yeah, so and that's a good thing to draw out, because being right, being correct, having a strong case even, that may still not give you the outcome that you want. So you could be right, so to speak, but the costs or the potential outcomes are just not worth the fight. They're not worth the risk. So some reasons why that might exist on the front end is maybe the damages that you could recover are too small compared to the cost of litigating it. Maybe the time frame for recovery is too long to make it make sense. Maybe the contract if you're litigating over a contract, maybe it doesn't allow for you to recover your fees from the other side. So the cost of getting there is too much for the potential outcome. Or maybe the other side just doesn't have the funds to pay if you do recover. So when you're thinking about all these things, you don't want to think about litigation as just this truth finding exercise. Am I right or am I wrong? Really, it's a business decision that needs to be thought of like within the spectrum of other business decisions. So I think smart business owners are asking, like, even if we win, is it worth it? Does it make sense for us in the scope of everything else we're doing as a business?
And Kevin, what contract terms matter most before a dispute happens?
Well, if you're litigating over a contract, the first place to start is to look at the terms itself. So I've already mentioned, can you win your attorney's fees? Usually that's dictated by the terms of the contract. There's a lot of other things, venue and jurisdiction, where we're going to file a lawsuit and what laws apply. There's things related to performance. limitations of liability is a big thing. If we're talking about restrictive covenants, how to enforce those things like non-compete agreements or maybe ownership of intellectual property. So we're going to be looking at all of those things on the front end to determine really the rights and how strong of a case we might be litigating if it is, like you said, a contract-based litigation matter.
And then how do emails, maybe informal communications, how do those affect future litigation?
Well, we live in the digital age, so there's a record created for everything we do. So whether that's, a conversation that happened, we're looking at emails and Slack messages and calendar entries and payment records and all those things. And a lot of times when we're looking at communication specifically, communications that are made contemporaneously with activities or underlying facts that are happening are can be very determinative. And more of those things are recorded in, like I said, in emails or Slack messages, text messages, things like that. So when we're looking at that, the way things are communicated at the time can be very determinative of the outcome of a case. So if things are stated in a way that's inaccurate, or they're overly emotional, or they don't really record things appropriately, all those things can really affect the strength of a case later. So a case that might maybe have seemed very strong, once you actually look at the communications, that could really undermine a strong case, or it could establish a case where you think maybe one didn't really exist before. So understanding all those communications and the records underlying the facts of a case is very important on the front end.
And then what steps should a business owner take when a dispute first appears?
Well, this is a very important stage, and unfortunately, a lot of mistakes are made in this stage because when people all of a sudden there's a dispute that comes up, a lot of times they react emotionally. They say things that they shouldn't say, like they make admissions. They do all kinds of different things. The first thing really is go talk to your lawyer. On the front end, doing that is going to prevent a lot of problems, and it's going to help you establish a plan. You're going to understand, what leverage you have, where there might be weaknesses in your position, things that you should do in terms of preserving documents. And then you can make a plan that's going to set you on the right course from the beginning rather than setting you on the wrong course from the beginning, as many people do.
And you said go talk to your attorney first. So, am I hearing you say, please don't go gather evidence? Please don't go digging into this on your own. Meet with your attorney first, come up with a plan, and then we take the next steps.
Yeah, that's got to be the way that you approach it. And I think a lot of people, they do feel like they're doing something right when they're doing different things like, talking to other people and gathering evidence. But ultimately, they may just be doing things that are either creating new problems, or just really not focusing their efforts in a way that's going to be helpful. And so I'd say that that first step of getting a strategy, talking things through, understanding the lay of the land, so to speak, before um, you know putting efforts towards executing on different things. That's really the way that you've got to approach it.
Are there specific steps that attorney can help with before the lawsuit stage? Like being more specific, more detailed, if you could give us some of those.
Sure. I mean, we talked about contract provisions, right? So actually, if it's a litigation over where there's a contract in place, actually digging down and understanding all of the things that would apply, and whether or not there is a strong case, whether or not there are weaknesses, whether or not there are ways to recover attorney's fees. And so, for instance, if you know that on the front end, that might affect really whether you are going in swinging or going in and trying to reach a resolution. Helping understand and frame the communications in that way in light of knowing how strong of a case you have, that makes a really big difference. And then assessing the economics of litigation, for instance, like you, as we talked about earlier, if you may have a really strong case, but it may not make sense to pursue it. So, going in swinging, as I said, with a litigant that maybe it doesn't make economic sense to pursue them, being able to talk through those things and understand the strategy that makes sense for every particular situation, that really dictates, how you're going into a dispute informally or formally, like filing a lawsuit, and whether or not you should do that at all. And so I think those conversations can prevent a lot of problems, and also, as I said, set a business owner or executive on the right path when they're trying to resolve a dispute.
And I know that we're talking about litigation specifically, but does it make sense to move forward with a case in hopes of settling it, not to take it to litigation?
considerations are really not legal at all. It's practical and economic. What makes sense for your business at this time? If you're a business owner and you're getting ready to sell a business, for instance, 6 months or a year from now, does it make sense for you to get into litigation even if you're right? A lot of times that might scare away a potential buyer. So that might be one thing that has to do with the particular situation of a one business where maybe everything else lends itself to saying, yes, let's file litigation. But if you're talking about what are the goals and strategies and bigger picture of that business, then it doesn't make sense. And so, the approach is not to just look at the case itself. It's not to just look at the rights. It's not to just look at the economics, but all the big picture things about it, so that as a lawyer, when you're giving advice to a business, it's good advice based on their particular circumstances. And those would change from situation to situation, and it's got to really depend on the richness of that conversation to determine if you're going to get the right outcome of talking to your lawyer about it.
And would you say that's the ultimate takeaway for the business owner?
I would. I would say, there's a couple things if you're listening today to take away. So one of them is, before a problem comes up, as a problem comes up, talk to your lawyer. Make sure you've got everything in place. And even honestly, before a problem comes up, if you get your contracts reviewed, you've got a lawyer that understands your processes, knows your goals, and all those things. A lot of that preventative effort can really be very useful down the road. Um, as I said, a lot of litigation, it starts before the lawsuit is filed. So getting contracts in place and processes, making sure that things are buttoned up the way that you want them to, and then ultimately, when things do go a certain way, when disputes ultimately do come up, you've got everything lined up the way you want it to, but also you've got a good advisor to help talk you through the next phases of the plan.
Kevin, I think that's where we'll leave it here today, unless you have any final thoughts.
No, I think that's it. Make sure you've got a good advisor and make sure you've got things in place the way you want them to be.
If your business is facing a serious dispute, do not start with the question, can I sue? Start with the better question. What is the smartest business outcome? And what legal strategy gets me there? At Brick Business Law, their lawyers work with business owners to evaluate risk, protect leverage, and make practical decisions before litigation takes over the business. Visit them at brickbusinesslaw.com for a free consultation. And we'll see you in the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.